where it starts by saying, it was decided in the meeting. Lordships get that. It was decided in the meeting to conduct the classes as per the previous system until further orders will be issued by the Director of Pre-University Education Department. They wanted to refer this matter to the Department of Pre-University Education. Until that decision comes, we continue with the status quo ante was the decision. But Lordships will also see the tenor of the meeting. The parents of the students were called. They were told that since 1985, this progress has not been there. There would be no impediment for your education. Kindly continue. This, after this resolution came to be passed, I am told words and I am instructed. It did not help. They continued with this insistence or protest, saying that they would not adhere to this and they would continue to wear hijab. Now, this led to a communication to be made by the government to the Director of Pre-University Education Department at page 23. My lords will also note in this letter a reference by a letter written by the chairman of the Karnataka Minority Commission, Sri Abdul Azim, on 17/1/2022, as regards this subject. Now, kindly see how the government reacts or responds to this situation. With reference to the above subject, on bringing your notice to the letter referred above, uniform has not been prescribed and not made mandatory for the students studying in state pre-university colleges. But the girl students of Government Girls Pre-University College, Udupi district, were urging to allow them to wear the clothes. Some typographical errors are there. Lordships may pardon me for this. Where the clothes of their choice were informed about the uniform dress code prescribed by the college while getting admission, and they had obtained enrollment in the college only after agreeing to the said information. But the issue which was not there so far has been raked up now, and this is not good in the educational interests. In the background, it is necessary to constitute, but this is it, a high-level committee to review the existing uniform dress code for students of various state pre-university colleges and to contemplate regarding uniform dress code for the students of pre-university college on perusing the judgments passed by the Supreme Court and High Courts of various states. The government needs to take necessary action after examining the recommendations submitted by the committee upon conducting a study. I have been directed to inform the Government Pre-University College, Udupi, to take measures at the level of the institution itself to maintain status quo in respect of the issue of the uniform dress code prescribed for girls students. I'll pause it for a moment. When the government came to be intimated of this sensitivity of the issue, we said that we will constitute a high-level committee consisting of various persons. We'll examine what are the judgments of the courts and also the issues relating to as to whether what is the dress code to be given, including this issue relating to hijab. And until then, please maintain status quo. This was the communication we made to the Pre-University Education Department, asking him in turn to communicate it to the institution. But based on this, on the same day at 25/1/2022 at page 27. When is this? Another resolution came to be passed by the College Development Committee. At page 29, lords, it was decided that the status quo ante should be followed. Practically, there is a plea to the parents of the children. Please follow whatever has been prescribed. At last paragraph, it will lead to indiscipline, etc. Institution notes that there are more than about 900,000 students studying, because of 6 of them which should not be affected. Anyway, this resolution came to be passed. But I will stop here. After this order came to be passed, interestingly, this writ petition was filed at this stage itself. The present writ petition, which my lords are examining, 29/1/2022, this writ came to be filed. There was no government order of 5/2/2022. There was no further resolution on 31st January, which Lordships will get it later. The prayers, of course, but being 226 proceedings, I do not want to not sound very hyper technical, but all sorts of prayers are said. Initiate action against the MLA, initiate action against the officers, etc. And some of the grounds which have been made is that the wearing of hijab forms some sort of a the right under the act. On this note, notice was issued to the state, and state was to respond. But I am told the matter did not rest there. In the institution again, this unrest continued, which led to another resolution being passed on 31/1/2022 at page 37. At page 37, is the last of the resolution passed by the College Development Committee. This reiterates the same thing, except in this, I must say, at page 38, last sentence, they make a positive assertion that children should not be wearing hijab. This has been produced before your lordships only for this purpose. He also informed that if the parents send their children with the hijab, a disciplinary action shall be initiated. But I must point out here, but this the resolution also notes something very important at page 37, second paragraph, very subtly put across by the committee. He intimated the parents that the students of all community are learning in this college, and interest of those students is very important. Opposition from all other communities is receiving due to one community. That should not be allowed. The concern of the committee is reflected in that. It was in that background what this statement came. Now, this, I'll state, this resolution is not called into question either before this court or before any other forum. Yes. Now we come to this very stage just before 5/2/2022. By this time, the state government was flooded with issues relating to that this issue of this institution is spreading to other institutions. The issue relating to wearing hijab is turned into a religious one. The intervention of the state was therefore not called for, because it did not remain localized to one institution. It was being projected as if the state was doing something in this matter, state was intervening in this matter. But naturally, lordships have seen earlier we had taken a stand that we will constitute a high-level committee to look into this, but they did not heed to that. The protests and the unrest went on. It is that background, page 42, the impugned order has been passed. Now, Lords, most importantly, Lords, but I will show before your Lordships what is the purport and impact of this order. Because one of the submissions or propositions we have made, Lords, before your Lordships is this order dated 5/2/2022 is innocuous in nature, does not interdict any of the rights, if any, Lord, of the petitioners. Lordships may kindly note this, and I will demonstrate before your Lordships why it is said so. 5/2/2022 Lord, does not interdict, does not affect any of the petitioners' rights. But when Mr. Kamath was submitting before your Lordships, Justice Dixit made an observation. The orders must be read as they are. They must be, words must be read in the which they are accompanied, and they cannot be read like statute words. I cannot put it across in any better manner than what his Lordships has put. A plain reading of the order, Lordships may kindly now see what it results in. Except not, there could be contentious regarding certain English translation, but I will not trouble your Lordships on that. I will bring to Lordships what is the purport of the order at page 44, operative portion of the order. Much has been made out by the recitals in the order, that also I will justify. But kindly see ultimately what is that we direct. In the light of the circumstances explained in the proposal, in exercise of the power conferred under subsection 2 of section 133 of the Karnataka Education Act 1983, the state government, this is the first statement, state government has ordered that the students shall compulsorily wear the uniform prescribed by the government in all government schools. Lordships may kindly note this one. In respect of government schools, whatever uniform the government has prescribed, please wear that. In respect of private schools, students shall wear uniform prescribed by the management of the school. This is the second.
No, the government has not prescribed any uniform.
We have prescribed. We have prescribed. Insofar as government schools are concerned, we have prescribed in this manner. I did also find out. But what we do, government is under that Vidya Vikas scheme. In fact, children are given free dress, free uniforms insofar as government schools are concerned. And
uniforms have been prescribed by the development committees.
So, this is only for schools. This is only, the first portion relates only to school. Second portion leads to pre-university college. I'll come to that. First portion only to government schools. Government schools, what we say, whatever we have prescribed, please wear it. Insofar as private schools are concerned, we say whatever the management prescribes, please wear it. The Lordships may can. Second, insofar as college, PUC colleges are concerned, we say, Lords, it is ordered that in the colleges under the jurisdiction of Department of Pre-University Education, the uniform prescribed by the College Development Committee or the Supervisory Committee of Management of the respective colleges shall be worn by the students. But I will, Lordship, I will definitely justify what is this College Development Committee, why we have it. But the purport of the order, what we say is, insofar as PUC colleges are concerned, whatever college development, I'm only now trying to bring to Lordship, kindly see the state's view. We are not interfering. We are saying whatever the College Development Committee fixes, you please follow that. The next sentence is, in the event of the College Development Committee is not fixing so, but here our draftsman has become over enthusiastic, unnecessarily writing. He could have seen all that he meant was students shall wear the dress which would depict equality, unity, and public peace or reason. But they have gone into affecting law and order. All that what he meant was please wear dresses which would inspire public decency, nothing more and nothing less. But Lordships may for a moment not see the effect of assuming that sentence was not there also. But it would not have made a difference to the order. So the intervention of the state, your lordships will now kindly see. On 29/1/2022, we said we will constitute a high-level committee who will look into this issue relating to hijab. But when it went up, we said state will not take a stand this way or the other. We said we leave it to the complete autonomy of the college development councils insofar as pre-university course is concerned, and schools are concerned to the private institution to prescribe whatever dress you want to wear.
Dress that goes well with the idea of equality and unity.
But that is, yes, but what we say is, in case they are not prescribed, please wear dresses which do not, not very indecent, do not go against it. Something which you could have put it across in a better word, but it does not say anything more, anything less than. The question of hijab, lords, unless they want to read something which I am not able to read, but I have read it 10 times, these 2 paragraphs. Question of either asking an institution to proscribe, they use that word, or prescribe hijab does not arise. Where does the state come into picture? And I'll say, but I'll bring to Lord's notice why they have unnecessarily dragged us into this, made it into an issue. When Lords, on a plain reading, 5/2/2022, state does not say whether we have asked them to prohibit hijab. In fact, we have given complete autonomy to the college development councils as well as to the institutions, private management institutions.
All right, but
No, I'll just complete this thing. After something which lordships may kindly, after 5/2/2022, very interestingly, till this day, though my lords are hearing them, but we have not received a single complaint about any college council or a school having prescribed any resolution which has resulted in unrest, or where our intervention has been invited.
what we want to know is that what is the background of this government order which you have mentioned before issuing of this government order? What was the necessity of all this?
No, the necessity was on account of these resolutions which came to be passed on 31st January 2022 by Government Pre-University College Udupi. And our earlier communication where we said that we will constitute a high-level committee. There is tremendous pressure upon the government to decide one way or the other what should be done. At that point of time, the government has taken a very conscious decision for not to enter this
government order is very innocuous. It only says that in the schools, whatever the uniform is prescribed by the government, that is to be worn, and in the pre-university colleges, the university prescribed by the committees, that is to be worn.
Yes. But that now, is how. I'm sorry.
Come to the earlier part of this order.
Yes.
Where you have said that these consider these judgments, and then you have said that this page 44, as per the judgment passed by Honorable Supreme Court and of various high courts of different states mentioned above, directing not to attend school by wearing headscarf or covering head is not in violation of Article 25 of the Constitution. Where was the necessity to say all this?
Lord, so now, Lord, by this time, lordships have seen that. But these are what is
suggesting something.
Yeah, sorry.
You were suggesting.
Why? No, that is just what I am before your lordship. But we are there could be something like we are indicating to the authorities below that you do something about it. Of course, not now. If I can only go by what is the letter, what is prescribed, what is there, which is therefore we say an operative force. Any other suggestions, which we have given it?
If we accept your argument that this government order is very innocuous, it only talks about whatever the uniform has been prescribed, that is to be worn by the children.
But I want to make this. That is the stand of the state. But today, the allegation against the state is you have now I'm speaking and we'll come to that other issues relating to hijab, how the school behaved in the matter. That is a different aspect. So far the state is concerned, but they're very conscious. We have consciously kept ourselves away from this. We have given it to the decision autonomy of the college development councils to decide upon the uniform, including the issue relating to hijab. Of course, but there is a
meaning thereby that if the development committees decide to permit the students to wear hijab, you do not have any objection to that?
But may I respond? Yes, I'll respond to that. Well, let us say the possibility, but there is a possibility. But the college development committee may decide that we permit hijab. But we have something called, I must point out, under section 131 of the Education Act, revisional powers. If any of the students or if any of the authorities are to come before us with a grievance that this would result in something else, but possibly the state may or may not take a decision. But as of now, the fact that in the order we give an autonomy to them, but kindly visualize another situation.
So,
what would have happened if I had said, sorry, I'm sorry.
You mean to say another 50,000 revision petitions should be filed before the government?
No, certainly not. No, certainly not. But certainly not. But we have very consciously, the state has taken a stand. Appealing to the autonomy of the College Development Council to decide the issue. But the College Development Council can decide the issue one way or the other.
But you have not left that option.
But we have. But that is what, of course, now the question is how they have understood it.
No, we have understood, right? At least judges understand.
But if lordships feel that the paragraph just above the operative portion indicates that hijab should be banned or proscribed, but I will clarify not as an advocate general. That is not the purport of the order.
No, in so many words, you have not stated wearing of hijab should be prohibited. You have not articulatedly put it. But for a commoner, these orders address common people, market people, punctus punctilio people. Is it not? These orders are meant for that only. College teachers, students, parents, members of the CDC. How they will interpret this, how they will.
I will answer the question straight. But I will state once again before your lordship, what is the conscious stand of the state? But conscious stand of the state, with all responsibility, I'll make the state. Is what we do not want to intervene in these matters, insofar as it relates to religious symbol issues matters in the educational institution. The reason is this: if we are to, let us say, if we are, instead of doing this exercise, roundabout exercise, we could have very well, I'm not sure what would have been its validity before your lordship. We could have very well said that on an examination made by us, let us say the order was to say, the insistence of students to wear hijab according to us would lead to disruption of a secular atmosphere in the institution, thereby degrading the academic standards. Now, I'm just bringing to that. Therefore, we direct each of the college development councils to prevent and prohibit headscarves, which is called hijab. I do not know whether they could have passed that order. But if the state wanted to do so, nothing prevented it from doing so. Why I am making this submission for your lordships? In all responsibilities, this is the stated stand of the state. We did not want to intervene. And if we lordships ask us to take a stand on these issues, possibly, that is the reason I mentioned 131. There is one provision, but if somebody comes before us, and says that they have permitted CDC, which is not, for whatever reason, possibly but it may require some amount of thinking and elaborate consideration before a decision is taken. Now, what's coming back, all that I am saying before your lordships is, penultimate paragraph above the operative portion does not, lordships have said that may give an indication, but my submission before your lordships is, all that it records is a judgment of the Kerala High Court, Supreme Court in Kerala High Court.
What was the necessity to mention all this? But that is to say that this government order is an innocuous order.
The background was this SDMC, the Udupi government colleges issue, which was the foundation for this. But finally, the government took a decision. Not all that I am bringing to lordships notices, and what this state is not stating this before your lordships. By the order, we have not instructed, and we have left it to the autonomy.
No, let us understand. Yes. Let us understand the effect of the order.
Yeah.
Do you mean to say that the paragraph which Honorable Chief Justice has confronted you with,
the one which is just above the operative portion, yes,
operative portion, whether the colleges or the schools, whichever, can they ignore that and prescribe the?
May I answer?
Yes.
But I am not saying it. The government order says,
You are defending the government order.
You put stand which I have taken on the issue of hijab, but we have filed an affidavit, and I will justify before you on a different issue, on a constitutional issue.
No, that we are only on geo right now.
This issue, we have left it to the complete autonomy and decision-making process of the institution. But I cannot improvise or say something about the government order beyond what it is stated. But if this gives an indication, that indication, the paragraph, which it gives an indication to the institution, it is something which the institutions must understand. But of course, not that paragraph also, lordships have seen, is nothing but not recording the judgment of the various high courts. Now, Kerala too.
We just wanted to know the necessity of mentioning all these judgments and thereafter recording your conclusion and thereafter issuing the government order.
No, on a better advice, possibly those things could have been avoided. But now that they are there, but my endeavor before your lordships is, yesterday I was thinking of this. Yesterday I was thinking of.
It appears that they do not take your advice.
Sometimes it is less said the better, they say. But the government officials are very good in these things. I do not know how in this one they are always. But anyway, all that the submission which I am making before, the legal submission I am making before your lordships is the attack on this government order dated 5/2/2022, saying that is irrational, it gives a communal color. I mean, it discriminates Muslim women under 15. One absolutely is without basis. Absolutely without basis. Not only we have stated that, so my statement, lordships may record, we have left it to the institution. I have repeated it number of times.
That we have noted.
Yes.
It does
The
not
other
affect,
aspect,
you say that it does not affect the right of
it does not, on a plain reading, it does not.
And it is totally an innocuous government order, and government has left it to the institutions to decide about the issue of the uniform.
And and there is nothing but post facto this order. There is nothing before a lordships, wherein some committees have come before the college and said, look at the state government directed us to do so, therefore we are prohibited. The petitioners have not placed anything before.
Now let's come to the next.
I'll come to this note, I'll have to say something else before. Now, this order, therefore, innocuous, does not contradict, therefore, no cause of action. What's his mechanism? Now, Mr. Kamath, two submissions he made, non-application of mind, he said. But non-application of mind, what he was trying to say was these judgments, some of them are not relevant, some of them are relevant. That's what I don't think I should not request lordships to unnecessarily digress on this, because our submission is not this. The officers sometimes record those things, but I said I was thinking
we will say more application of mind.
More application, more enthusiasm is what I. But in fact, I was just thinking of a provision in civil procedure code. Lordships are aware there is no appeal against finding. So, assuming this finding is against them, the operative portion is in their favor. The question of assailing this order, saying that the finding is wrong, does not. Of course, it is on that question. That there is no finding, there is no adjudication on this.
1952 Supreme Court, Govardhana Das Bhanje versus Commissioner of Police.
Yes.
Page 16, AR 52 Supreme. That says, a statutory order, because it's your contention that this is a statutory
yes,
order, referable to 133. A statutory order, if challenged before the court, its validity has to be adjudged based on the grounds stated therein and not the horse. 78 Supreme Court, an order of the government is not a wine that becomes better as the time still serves.
Mahinder Singh.
Mahinder Singh.
Mahinder Singh case.
78 Supreme Court.
Mahinder Singh case.
Constitution bench.
No, Mahinder Singh case, but all that I was not on the technical. What I was trying to bring to these findings, these observations made in the court are something which do not form the foundation, because as they say, ultimately the operative portion itself decides the issue. Now, one other argument which has been made by Ravi Varma Kumar, Learned Senior Counsel, is this College Development Council Committee is an extra statutory authority, and therefore giving them the power to fix these uniforms, maybe without jurisdiction.
He also said that government has yet to take a final decision with respect to the that you have constituted a high level.
Yes,
committee.
29th January. That is correct. That is correct.
So the high level committee has not yet taken any decision. His government has yet
correct.
to take
That
any
is
decision with respect to the issue of uniform.
Correct. That is correct. I put this.
Or at least you should have stated, we had earlier thought of constituting the committee. Now there is so much tumult in the society. Therefore, we give up that decision and make this order. That's not your case. Even in the pleadings, you have not stated that.
Earlier, that high-level committee which we wanted to constitute was in reference to number of representations we received. Now we have left it to this college development councils. But possibly the idea of continuing with the high-level committee, I do not know what the government has in mind, but I do not have instructions as to whether they have given up or they still want to continue also is something which I can find out. So
No, whether it will not amount to that, this government order of 5th of February was premature. Because once, on the one hand, you are saying that a high-level committee has been constituted and the decision is to be taken by the committee. On the other hand, you are issuing a government order directing the development.
I must say, the government, relating to exigencies of situations, etc., issues these orders, particularly in exercise of 133 subsection 2. There are arrangements which are made, but it does not have any prejudicial effect to anyone. And so that
it will not amount to contradictory stand of the state government.
No, certainly not. The reason is not because 29th Lordships, I showed for your Lordship the rules. In fact, the rules prescribed it is the institution itself which has to this 29th order was a broad-based committee we wanted to do to understand how to go about these very unusual situations which have arisen. These are not very usual situations of fixing. Normally, the government never enters into this area of fixing the uniforms for the entire institute, entire state. These are unusual situation came up, and therefore that committee has been formed. It is a question of contradiction. Now we say that College Development Council shall fix these uniform, but this is in accordance with section 133. But I wanted to point out before your Lordship's notes how this 133(2) itself has been exercised. For that purpose, Lordships may kindly see this Karnataka Education Act, statement of objects and reasons. Yes, I'll just. Therefore, I'll just. This is an unusual act, Lordships have seen it. Karnataka Education Act 83, but it came into force only with effect from 1/1/1995. Almost for 12 years, it was not brought into force. One second. Right. But preamble, shall I just read? This becomes relevant because this has to be now read in context of section 133. It's a very short one. Whereas it is considered necessary to provide for the planned development of educational institutions, inculcation of healthy educational practice, maintenance and improvement in the standards of education and better organization, discipline and control over educational institutions in state, with a view to fostering the harmonious development of the mental and physical faculties of students and cultivating a scientific and secular outlook through education. I cannot say. The act itself entirely is directed towards the betterment of the student community, to build them into a better citizen by inculcating scientific and secular outlook through education. A few other provisions, Lordships may kindly note here itself. Applicability of the Act, section. This may do not directly relevant. No, I just give the overall how the Act functions. Section 1, subsection 3 makes it applicable to all institutions except what is ICSE, CBSE. Institutions maintained by those exempted categories wherein no specific provisions are made. It's been some amendment, I'm told.
They amended the act itself, bringing the ICSC. The rate of single judge.
Just Nagmohan Das, but may I draw Lordship's attention to the definition of education institution, which maybe becomes related. Section 2, subsection 14 means any institution imparting education referred to in section 3 and includes a private education. Therefore, a government institution and a private educational institutions are covered. And what is now important is Lordships may kindly note the definition of recognized educational institution. The reason is that this word appears in Rule 11 of fixation of uniform. Kindly see 2 subsection 30. Recognized educational institution means an educational institution recognized under this act and includes one deemed to be recognized thereunder. That is what's registered, recognized, and deemed to have been recognized. But the scheme of the act is what when a private educational institution is set up, they seek a formal recognition to the government under section 30 Lordships mechanism. 30. Section 30 Lordships. What is section 6? Lordships have seen section 36 months. 36 relates to recognition of a private educational institution. That is what they make an application, we consider all that. But what happens to a government-run college like this PU, Udupi College, is taken care in section 38. Lordships care that 38. Notwithstanding anything contained in section 36, educational institutions established and run by the state government or any authority, sponsored by the central or state government or by a local authority and approved by the competent authority in accordance with such conditions as may be prescribed, shall be deemed to be educational institution recognized. Therefore, we are deemed recognized.
No, formal recognition is necessary.
Yes, okay. Yeah. So the reason why I'm mentioning this words is under Rule 11, they speak of a recognized educational institution which will fix the uniforms. But insofar as, since we are addressing this issue relating to College Development Council, kindly see how a private educational institution is managed. And that Lordships will get it at page 40, section 41. There is an elaborate procedure. The managing committee is at page 42. Section 42, I'm sorry, section 40. That is, Lordships are fully aware of private education, how managed. Interestingly, I'll pause it, for a government PU college, there is no concept of a managing committee. Now, kindly see Rule 11 once again for the fixation of uniform. Lordships have get that. That Rule 11 of this Karnataka Educational Institution Classification Regulation Rules 1995. Provision of uniform, clothing, textbook, etc. Every recognized educational institution may specify its own set of uniform. Such uniform, once specified, shall not be changed within a period of next 5 years. Very innocuous provision, no difficulty, but now it has been made a bone of contention. Every recognized educational institution shall fix up. Now, Lordships have seen, insofar as the private educational institution which is recognized is concerned, has a managing committee. For whatever reason, insofar as our colleges are concerned, we do not have a managing committee. The question, therefore, before the government was, and who should fix it? Somebody has to do it to fix the uniform on behalf of the recognized education. But that was something which, in that context, in order to give effect to these rules and to the Act, Lord, we exercised power under section 133, subsection 2, Participant Candidacy 130. Of course, not. This is some sort of a residuary powers, overriding powers, or something which lordships may characterize it. Subsection 2, the state government may give such directions to any educational institution or tutorial institution as in its opinion are necessary or expedient for carrying out the purposes of this Act, or to give effect to any of the provisions contained therein, or of any rules or orders made thereunder, and the governing council or the owner, as the case may be, of such institution shall comply with such every institution. Subsection 3 also, lordships may kindly see, the state government may give such directions to the officer or authorities under its control, as in the opinion are necessary or expedient for carrying out the purpose of this Act, and shall be the duty of such officer or authority to comply with that. I'll just leave. Though I am tempted to cite 143 also, 142, which is power of to remove difficulties. I'll just only bring to lordship's notice that we had to put this Act into operation, this rule into operation. We did not have anything. We have time. So what is interesting, which lordships will note now, is that college has not called into question this order. The constitution of College Development Council is not for the first time we have constituted, it is there since 2014, and it performs various other functions as well. None of the colleges have come before your lordships or before us saying that this is something without authority. Students come before your lordships and say that no, that authority is without something which is extra statutory. But that challenge itself, lords, according to me, must fail on that ground. But to give effect to this provision of Rule 11, this power under 133, subsection 2 has been utilized. Lordships may also read the power to remove difficulty clause under section 142. And lords, I may complete this by also stating section 7, which empowers the power of government to make rules. Lords. 7, again a residuary power has been given.
But this is not generally, yes, such removal of difficulty clauses appear in new policy evolvement. Yes. There, orders made under such provisions, going by the patterns of the orders, perhaps with your long experience, you might have seen them. Such orders quote that section for the purpose of removal of the difficulty.
No, I am completely in your hands. This is something which we improvised, the Henry VIII clause concept, which we used in wherever we. But 133 subsection 2 is what we have. This is ultimately what I was thinking of. This I was thinking about whom shall we. If I had said given it to the principal, Ravi Varma Kumar sir would have come and said, no, he's an employee. Why did you give it to him? If I had given it to DDP, I would have said, no, he's an officer. We have given it, but there was criticism to this SDPI. CDC. I want to place on record something. But kindly look at the Constitution. There cannot be more representative character. Sorry.
So we just wanted to get one more clarification.
Yes.
The circular which you showed for constitution of
2014.
That for constitution of the College Development Committee.
Yes.
That has been issued by Under Secretary.
Yes. Yes, ma'am. The government. Yes.
Can it be treated to be a direction under 133?
The order notes of 31/1/2014 notes. But obviously we may have to trace it to that power only. There is no other provision by which, because this has been done not in order to ensure that better.
It is not a government order.
So this is a government order. My lord. This is a
It is
government.
not a notification.
No, this is a notification.
It is a circular issued under the authority of Under Secretary only.
Normally, my lord, these are issued in the name of Under Secretary, my lord, but it carries the approval of, if I may
That
say
is what
so.
we want to
No,
know.
it carries the approval of the ministers.
That is what we want
No,
to know.
certainly, Lordships may take it from me with my experience, but this document I do not know. I can surely get that certified, but Lordships
Whether
may.
the approval of the government was
Concerned
there or
minister-
not, whether the approval of the government was there or not on this circular. This
Most
is-
certainly, yes. Most certainly, yes, Lordships. I'll produce the original document before your Lordship. Should not be a difficulty. But I am very sure, not a very important circular wherein a MLA of every constituency would be given this power would not have gone without the approval of the minister concerned. I will place it.
Yes.
Yes. Now, yes, all government orders are issued in the name of. But therefore, my lord, my submission, I'll also place that 2014. I will get the original record. There should not be any difficulty.
Government orders are issued in the name of the government. The governor. In the name of.
Yeah, but in the name of the government, but
Yes.
that this our we have this rules, not same, just like issuance of government orders from ratification. It says in the name and by the approval of. Normally Under Secretary issue, but this file not I'll get, but Lordships may take it from me. This would not have.
Yes.
I was just on this representative.
This clarification would be required
I will
to appreciate your.
certainly, most certainly. I'll get placed there.
Under the transaction of business rules.
Yes,
whom
1977.
it is allocated, you have to show.
Sorry, I'm sorry, I could not.
Under the provisions of the transaction of business
Yes,
rules,
yes,
to whom it is allocated, this power, that you have to show
yes.
because of Parikar judgment of apex court.
Yes, Lord, I am aware. Chief Minister, Cabinet, and Minister concerned. 3 categories. I will show it. This is a very important decision. Getting the MLAs to, this would not have gone
We
without.
cannot presume.
No, I'm not for my place. I'm only saying it, some amount of experience for this guy. Now, I just want to point out the representative character of this committee. Lord. There cannot be something better than this. There is the local MLA, local person, parents representation, students representation, members belonging to scheduled caste and scheduled tribe. The principal is ex officio secretary, the vice principal, 2 teachers are nominated. The entire fulcrum of the institution comes together to take a more democratic. There cannot be criticism of such kind of committees. Let us say, for instance, this hijab controversy. There will be students representative, there will be parent teachers representative. It is not that the decision is to be taken by one person. Therefore, such committees being interested cannot be under no circumstances be termed as irrational. I will leave it at that. But one other as only for the purpose of record, though it may not fall really for Lordship's consideration, was MLAs must not take part in such committees, is what Professor Ravi Verma Kumar suggested. But I don't think that is our scheme. We have borrowed the Westminster model.
For governance.
Yes, it is therefore we have a political executive who are borrowed from the assembly who are executive. That American model of keeping the executive completely away from the elected body is not number one. Number two, under the scheme of the constitution itself, under Article 102, insofar as members of parliament are concerned, and 190 for members of the legislative assembly, there is disqualification attached if you hold an office of power. That is the only restriction for an MLA to hold officers. If not, there is no other restriction for him to become part of the committee. Anyway,
No, that is,
that
is disqualification for holding office of profit. It's a totally different concept. It does not admit here at all. We are asking, they were saying, and we are repeating now.
Yes.
That we are saying what they had said.
Yes.
This time, MLA from X party.
Yes.
Next election, MLA from Y party,
Yes.
Z party, A to Z, and so many parties, or independent MLAs also. Those political views will enter the campus. Is it desirable? It is not that we have no respect for the MLAs, etc.
Yes.
They are very important, and without them, there will be no government, no legislative body. But point is, MLA is a character, a more political character. This is how Sir Ivor Jennings, Casey Ware, all they treat that way. Whether that character should have overtone in the administration of the institutions is at their concern. Not this party, that party.
No, I understand. I understand.
To all parties we have got respect, and
Whether politicians should enter the campuses at all.
not politician,
No, I mean,
elected representatives.
members of the legislative assembly, yes, sir. Matter of course, a debate in a different context. But this one, I will, my submission before your lordship is that it is in these circumstances why the government intervened, or rather did not intervene, but I will put it and left it to the college. But the unfortunate events which took place and the attack, not only I am pained, but all the people's concerned are pained at the way the government has been berated in these proceedings, saying that we are dictated by some other reason when we administered these orders. We have discriminated girls and women on the basis of these are not something, not absolutely not, with all emphasis, with all humility at my command, I want to place before your lordships and before a constitutional court. The state believes in treating everyone equal. And that we stand emphatically exhibited in this government order when we said we leave it to the courts.
There is another aspect.
Yes.
If there is a MLA as the chairman,
Yes.
kindly look into the text of your order.
Yes.
MLA, he is a nominee.
President.
MLA is the chairman or president. He is a nominee, will be the vice president. Whether other members you want to, means it's their argument. So many
I
words they
understand.
might not-
No, I
That's how
understand.
we have perceived.
I completely.
If MLA and he's a nominee, or two persons are holding that key position in the committee, whether the other members will have any role to play, except sipping the tea at the meeting.
The constitution, but I understand. I completely, I'm in lordship's hands. The viability, desirability of having them is a matter which could be debated either. Therefore, Lords, my submission before your lordship on this government order dated 5/2/2022 is, my lord, that is, it has been exercised in accordance with section 133 subsection 2. It does not interdict any of the rights. Therefore, the challenge has to fail. Lords may also note, no challenge to any of these orders which have been passed.
Which orders?
That
Constitution of
call it 2014 order. But now that lordships are examining it, I am duty bound to satisfy lordships. I will place on record the approval. What I am instructed to state is that challenge was not there, and to the committee or any other person.
Who appoints number 3? Come to Sadasyaru.
Yes.
That 31/2014.
Yes.
Sadasyaru. Who opts them? Who appoints them? Nominates them?
I'll have to find out whether it is done by the government or by the local committees. I'll have to find out. Let me. Because that is something very pertinent. Again, if it is given to an MLA, then there will be a group of his own persons. I'll just find out. Of course, not more contentious committees have been in the school development managing committees for SDMCs, which have there, of course, a lot of issues takes. But these are not just pre-university courses, not much of work.
Now we come to the second.
Yes, second. I'll argue that. Yes.
Practice of hijab is not part of
Yes,
essential.
yes, Article 25(1). But before Lordships go this issue, just one sentence I want to say. Kindly see the method and manner towards which the government order has been assailed before your Lordships. That's something which my Lords, I request Lordships to kindly take note. When it did not affect them, and that too, the timing 5/2/2022 is the order, subsequent to which no committees have fixed anything or there has been no controversy at all. Therefore, that is something which my Lords may kindly take note of. Now, Lord, the students now say in some of the petitions, because in this petition, this Ayesha Hazim Almas petition, this prayer is not there. But there's one other submission I am told. But there is provision under the Act where not students, in case they find any difficulty such to give a representation to the parent-teacher committee, which is constituted under Rule 12, and to the government under 131. No, I am just bringing it. No student will, except for approaching your Lordships directly under 226. No
Against,
such.
against what? Which order?
No, parent-teacher committee, Lords, Rule 12.
No, that's all right. Now there is a government order. You mean to say the government order should be challenged before the government?
Not 5 to
This is like seizures order going to be challenged before seizures.
Not 5 to 2. This grievance about not permitting hijab being worn, etc. Nothing has come before the government by way of a normal situation. That is what the normal students are expected to do.
What is that committee?
So, student parent-teacher committee constituted under Rule 12 to a redressal of the grievances of the students. Lordships may kindly see 12 sub-rule 5 to redress the grievances of the students and their parents, if any.
How you will come to know about it? Whether any student has approached this parent?
No, nobody has come. Nobody has come. Look, the reason why I'm mentioning it, if it was a case of an uniform, these things would have followed. But I will leave it at that. I will not say anything more.
Okay.
No, I'm told not to say that. There is no such grievances have been made. They have come before your Lordship. Some of them have not come before your Lordships and of course have raised it outside. The second issue about hijab being part of fundamental. But they say now, the way they have put it across is Mr. Kamath in primarily. They say that wearing of hijab forms part of essential religious practice. It does not, this is how I want it, this does not come in conflict with public morality, rather morality, public order or health. Neither does it interdict any other rights under Part 3. Therefore, prevention of me wearing hijab violates 25(1). This is what Learned Senior Counsel wants Lordships to hold and declare and read it in this manner. May I request Lordships to kindly see 25(1), Article 20. Yes,
Just want to
yes.
refresh our memories. There was one argument by another senior advocate, Mr. Yusuf, that even if it is not treated to be essential religious practice, wearing of hijab,
Yes.
then also stopping of it would violate Article 25(1) because the article under 25(1) is freedom of conscience,
Yes.
not only religion.
But I have an answer straight. I'll answer that. But 25 lordships have to see once again. Lordships have read it number of times. We have made lordships read it again and again. Lordships,
there is no rest judicata.
I have to be conscious. Pardon me.
We're happy reading with you also.
Just once, not just. Freedom of conscience and free profession. Justice Dixit.
Yes.
Yes. Freedom of conscience and free profession, practice and propagation of religion, subject to public order, then morality and health. And to the other provisions of this part, there is a comma. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion rights. But this is what I was looking right from Article 12 to 32. None of the fundamental rights have a clause something like this, lordships have kind. It non-obstante clause, if I have to say, very difficult for fundamental rights to say so. But still, it starts by saying subject to.
This is what we pointed out.
On the first day, Honorable Chief Justice pointed out that one only.
So this was something very subject to public order, morality and health. There's one other distinction I want to point out before your lordships, but just so that lordships will finally see. How is it distinct from 25(2)? Is, my lords, 25(2). This is something which I noticed. This speaks of the power of the state to restrict or regulate by way of an order. Kindly. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law to restrict or regulate. 25(1) does not speak of any law to be made by the state. There is a definite object behind that, but I will demonstrate. Similarly, 19(2), lordships, the freedoms available under 19(1) series can be restricted under 19(2) onwards by way of a law. So therefore, the 19(1) right can be restricted, regulated by way of a law under 19, well, law to be made by the state. 25(2), again, law to be made by the state. The concept of law to be made by a state is conspicuously absent in 25(1). It speaks of subject to public order, morality, and health. Therefore, as I have understood, how 25(1) requires to be given effect to is, if somebody is to assert exercise of that right, I'm talking right to exercise freedom, religion, the court, my lords, may have to examine as to whether this exercise, this right would conflict public order, morality, and health. In the event of there being a conflict, my lord, those three things will give way. This will give way to those three things. That is one possibility. The second test is to find out whether or not it comes in conflict with any other fundamental rights provided under Part 3. Then the question of prioritization, which is the other word, prioritization would come. These are the way 25(1) requires to be operationalized, I put it across this. So whenever a challenge comes before the court, somebody seeking to exercise right to religion, the first test, according to me, which requires to be applied by the court would be to see whether that right comes in conflict with the public order, morality, or health. Obviously, my lords, on an assertion made by the other side. Of course, if we are to, state is to come before your lords. The question of lords making a law by the state and being a law under Article 13 may not arise at this stage at all. All that we have to show before your lordships is, kindly look at this. During COVID period, lords, all the temples, churches and mosques came to be closed down. That is the essence of a religion. But for a Muslim, Mohammedan to go to a church, or for us to Hindus to go to a temple, for a Christian to go to church, it was closed down practically for 6 months, 9 months, 1 year. The reason is for health. The government, of course, they exercise the power under the Disaster Management Act, that is different, but that is the reason. Not communicable diseases. If a person says that I want to enter a place of worship, but if he holds a communicable disease, health, straight away the managing committee, the Archak, anybody can claim. We don't require anything else. Therefore, Lord, in every situation like that, the first test the court must take. Now that they have come up with this hijab, has to examine this, whether it comes in conflict with public order, morality.
Whether 25(2)
Yes.
is in the nature of an exception to 13(2).
That is law, lordships are referring to law.
Not only that, 13(2).
13(2).
The state shall not make law.
One second. That we are dealing with the most sacred portion of the Constitution. I do not want to immediately react. Let me get back. But prima facie, what I would feel is it speaks of abridgment or taking away the rights. This speaks of regulating and restricting. That is one possible distinction which can be drawn. And certainly, if it is to be held that the abridgment and restriction can be equated, then it becomes a exception, but I'm not very sure. Can we draw any? We can draw any.
Have interpreted these.
I will examine. I'll surely examine. But I was on 25(1). Therefore, the first test, lordships may have to examine. This is second test. Lordships may have to examine whether this comes in conflict with any of the rights. Now, it also speaks of, with lordships, Honorable Chief Justice, of very interestingly, freedom of conscience and the right to practice religion. But I did take that extra interest to understand what is freedom of conscience in this story. The first and simple explanation is what Durgadas Vasu says. I'll place it before you. Very beautifully put it across. Of course, there have been a number of judgments on that. But, what he says is what freedom of conscience is something which is you believe. Propagation of religion is your manifestation of outwardly exhibition. That is how he puts it across. And this is supported by a number of these. That is what he gives the example of Jainism, Buddhism. He says they don't believe in God. That is their belief, and matter ends there. But kindly see his very brilliant analysis at this on Article 25(2) when he is describing at 1, 2, 3, 4, fifth paragraph. Fifth paragraph in that page number. Page number 3519.
3519.
3519, 1, 2, 3, 4, fifth paragraph. Lordships get it?
Yeah.
3519.
35. 1, 2, 3, 4, 5. Fifth paragraph. Yes. As has been pointed out before, Article, Lordships get it.
Yes.
As has been pointed out before, Article 25(1) has two parts. A, freedom of conscience, and B, the right to profess, practice, and propagate religion. Religion usually assumed belief in a creator, or at least in the case of an atheist, in the existence of a life superior to our earthly existence. But there may be persons who do not believe in either of these two and cannot therefore be said to have any religion. Such persons believe in the fulfillment of human life in this earthly existence and do not admit of any existence apart from the mundane. The conscience in the case of such persons may be said to consist in non-belief. What this is. The freedom of conscience under Article 25 of our Constitution guarantees the freedom of such belief or non-belief, irrespective of the religious faith of such person. Where he has no religion, he has the guaranteed freedom to hold to his non-belief, free from interference or imposition from any other person. But this is very important for this sentence, which I want to. Freedom of conscience is thus a mental concept, while the right to profess, etc., refers to external action in pursuance of such mental concept of the individual. But the Constitution gives me the freedom to say there is no God. That is freedom of conscience. What is manifested? Give me England. House of Lords. House of Lords. European Convention, Article 9. That paragraph, that particular paragraph.
Freedom of conscience is only with respect to the
only for that purpose. What we manifest, what we practice outside, like Mr. Kamath, while arguing, gave this example. He said, I wear Rudraksha, that is my belief. No. Belief is not wearing Rudraksha. Wearing Rudraksha is your manifestation of your religion. Believing something to yourself is your freedom of conscience. Therefore, they use the word freedom of conscience and right to practice religion. Right is something which you can enforce. Freedom of conscience, you do not enforce anything. You believe in Buddhism, you just believe it in people. I believe there is no God, but I do. So they said you can still, in this country, we just do not want to give you to do something, practice religion. You also want to respect people who do not want to believe religion. Therefore, they use the word freedom of conscience.
You mean to say freedom of conscience is confined to only atheists?
No, certainly not. For instance, certainly no. Therefore, they have given the definition of Buddhism and Jainism.
In fact, there is in the Vedic literature,
yes,
there is one sloka. Prathama Pratima Puja, Japasthotrani Madhyama, Uttama Manasi Puja, Swaham Pujo. I do not do any puja at all. Because
yes,
I worship myself
yes.
lonely. So even that comes within the conscience.
No, I agree. That's exactly what I'm saying. That what you manifest outside by way of a practice is the second portion.
Not even outside. I do not do any puja.
No,
I do not do anything.
Yes.
Even that is covered under freedom of
conscience. No, all that distinction I'm saying is not. When you practice it outwardly, this word of Mr. Durgadas Basu, he says, he uses the word, I'll read it once again. It is a mental concept, while the right to profess, etc., refers to external action in pursuance of such mental concept of the individual. But that distinction is thin, but it's real. I must say, it is real.
Conscience and religion are two different things.
Two things, conscience and religion. Therefore, they use the word freedom of conscience, right to practice religion.
One can be highly irreligious, but may have very conscientious.
Yes.
One may be very religious, but may not have the conscience.
Yeah.
How makers of the Constitution understood this?
Lord, this is there. I have got the Constitutional Assembly, but I wanted to place it before. Just one other paragraph after that. He continues there itself.
Yes, that is very relevant.
Yes, only. Conscience, yes. Conscience and religion are thus different concepts. Conscience and religion are thus different concepts. And that is why both words are used in Article 18 of the Universal Declaration of Human Rights, 1948. The essence of the freedom of conscience is that it is a personal matter of the individual's own choice of the international covenant on political and civil rights. That freedom would be impaired if in the formation of the choice or change thereof, the free exercise of the individual's will is dominated or influenced by any other person. The mental aspect of the freedom of conscience must be remembered in any discussion under Article 25. Because of this guarantee of freedom of conscience, every person in India has an absolute right to form and adhere to his own belief in the matter of religion as in other matters. No one can therefore be compelled against his own judgment and belief to hold any particular creed. But the no, in this Convenient 9. English test, this same Universal Declaration. Or European.
All right, how to ascertain this conscience? We cannot follow me into the
But
mind.
my reading of Vasu, what I would, that therefore uses the word, it is a mental concept.
How to ascertain?
No, I'm just coming. When you propagate whatever be your belief, let us say, whatever be, let us say, I'll take again the example of Buddhism itself. Let us say I believe Buddha is the. Once I start exercising the practice of that religion, if I have to say so, then we come to the second one. Once you assert, you come into the realm of practice of religion.
That's true. What about how to ascertain? My question remains large again.
Assert,
answer the question.
Answer the belief, your lordship.
Yes, conscience.
Answer the, of course, belief or non-belief also, it comes in the world. That's how they have described.
I say,
yes,
that saluting a particular symbol is contrary to my conscience. How to ascertain?
I'm assert or ascertain.
Ascertain. A-S-C-E-R-T-A-I-N.
Ascertain.
I'm not good in English because I'm not taught in Kannada school.
I understood it as assert, so that then the practice of religion. Therefore,
how to investigate?
How to investigate
that conscience? What is the nature of conscience? Whether conscience is at all there? How to ascertain? This only reminds me of some Shakespeare's poem. We cannot fathom into the mind of the man, though we can in the mind of the devil.
Not sir, I would my lordships did ask me how did the constitutional makers thought of it. But I will place it before you in a particular order maybe tomorrow. But I'll just state before a lot what happened. When Dr. Ambedkar introduced this, but I've seen that one. Some of the members opposed it, saying that time this concept of freedom of conscience was not there. They initially introduced it as a right to propagate religion. The argument against this article was, no, you see, if you give this power, then there is a possibility of one religion being hegemonized over others. It is at that time Dr. Ambedkar intervenes and says, no, it does not just compel others to propagate and profess their religion over others. We also have freedom of conscience. That's how it develops, not that I'll place it. That seems to be, of course, with this concept which lordships are asking me, so surely not that how to ascertain. It is something which I possibly have to go a little bit read more on these aspects. But the freedom of conscience and right to propagate religion, the fundamental difference which Vasu makes not with, I thought is a very simple thing. He says, whatever you believe, it stops at freedom of, but once you manifest it outside, it becomes practice of religion. And Covenant
now, in the light of this, what do you say whether hijab is part of?
Therefore, hijab certainly comes in the manifest exercise of right to practice. According to him, it's a right to practice of religion. that it's a right they are trying to exercise pursuant to the religion. It is part 2.
My lord's question,
No,
yes,
we
question.
are on different question.
Yeah.
Whether the hijab constitutes the part of the essential religious practice or not.
But insofar as hijab being a part of essential religious practice, the answer is no. The answer is no. And why it is no, I'll possibly substantiate. Lordship, I can continue on Monday, Lordship.
All right. The Advocate General
No.
appearing on behalf of the respondent
No, Lord.
has placed his arguments in the record. The arguments of the Advocate General are continuing. Put up on Monday at 2:30.
The leave of this court, I want to make one submission, Lord. I want to make one submission with the leave of this honorable court.
Yes.
Lordship, all writ petitions are private in nature, Lordship. And Lordship has passed the interim order considering the amending law and order situation at that point, that 11. The order has very specifically in respect, para number 11, it is stated that it is only confined to those colleges where the CDC has been prescribed in uniform. But in spite of that, state has extended this order and enforced all the schools, degree colleges, all the colleges, Lordship. Even the schools, teachers also not spared.
Our order is very clear.
Yeah.
For that reason, Lordship, just one report may be called from the state, how it has been implemented down. Because Muslim community members are facing so much difficulty because of this order, Lordship. And every department is interpreting in a different way altogether. Every department, even yesterday, minority department has passed the order. Even where schools, which are Urdu schools, 100% Muslim populations are there. Teachers, all Muslims are there. They are enforcing that order, Lordship. This is causing a lot of chaos in the society, Lordship. Because our purpose was to prevent law and order situation, but it is creating further, Lordship. And the police are deployed in front of the gate. They are forcing Muslim girls and they are threatening if they are not removing. The order was set that in the class, but in spite of that, in the gate itself, police personnel are deputed to threaten them, to intimidate them, to remove their burqa and scarf.
Yes. Advocate General, you have.
Even the Kansas are not able to appreciate the I told Kasim convincing.
I do not want to enlarge this controversy. I could have easily said, let them come with an evidence. All that I'll request you. Let him give me the details instead of the court. But we will instruct suitably to ensure that nobody acts beyond Lordship's interim order. And I'll assure you, Lordship, there will be no cause of conflict. But provided not, he gives me the details in writing by way of a letter or something addressed to the advocate, so that I can act.
Lordship, I tell you my people. My petitioners are uses.
Let him go.
Let him not give affidavit. If I give affidavit, the question will raise.
Not
Advocate
affidavit,
General is saying, give whatever in writing, give your complaint in writing to him. He will instruct the authorities to act in accordance with the High Court's order only.
And let him be assured, there will be not even an inch.
Widely published in public media, in social media, all media houses, Lordship, how
Their stand is they are acting strictly in accordance with the High Court order.
That's the last for that reason I
feel that there any individual case there somebody is violating the order or acting more than what is mentioned in the order, then give it in writing, give the specific instance there, and they will act on it.
We will call the commission. I will ensure that it is done. Let him address a letter. In
addition to this, some report also will be called from the state, Lordship.
On what basis?
Lordship, on the basis of implementation of the order, Lordship. The order was, purpose for the order to maintain public order. Now it is creating divide in the society, Lordship. For that purpose only I am making submission.
All right, you file the application, consider.
Lordship, application, in which capacity I can file it? I am a petitioner, it's a private plea. It's a question creating chaos in the society. My humble submission, Lordship, if otherwise if Lordship will direct me to give a letter with all the proofs, I will provide it. I will submit it before the court also one copy that.
To him, he is very fair to the court. He is saying that he will act on it. Give it to him.
They're passing official orders, and even they are calling the minority institution TDP, and they're telling them to enforce that order. And they're saying it's a High Court order. Every year they're quoting, even Education Minister says it's a High Court order. I really could not understand how they're interpreting, Lordship.
Very difficult to respond if allegations are made against like this.
Even they are implementing this order in the schools, my lord. Small schools.
Unless anything is happening before us, we cannot take cognizance of that.
Our situation is very tight. We have very limited scope to address our grievances, Lordship.
Thank you.